So good morning, or depending on where you're joining us from today, good afternoon or even early evening in Melbourne. And I could not imagine a more exciting start to the week than to welcome you all for the second part of our webinar series on COVID-19 vaccinations and international law. My name is Rouven Diekjobst, and alongside my colleague Lisa Cohen, I will be moderating today's webinar on COVID-19 vaccinations and human rights. Now, as soon as they became available, COVID vaccinations brought contemporary human rights issues back to the forefront. From compulsory vaccinations to limitations imposed on freedom of expression or freedom of movement, COVID really had them all. Therefore, on behalf of Ruhr University's Institute for the International Law of Peace and Armed Conflict, in particular our research cluster on human rights and humanitarian protection, as well as the European Society of International Law's Interest Group on International Human Rights Law, it is our great pleasure to take you through a discussion on pressing issues surrounding the human rights issues connected to COVID-19 vaccinations with our distinguished guests, Marko Milanovic, Goldner Lang, and Sissy Katsoni.
Yes, good morning, good afternoon, and good evening, and a warm welcome from me as well. And it's truly a pleasure to welcome both our distinguished guests and, of course, also you, our digital audience for today from all around the world. And let me shortly brief you on some technical details for this webinar. After the presentations of our guest speakers, we will have a 30-minute Q&A section. And please feel free to submit your questions already during the presentations, and of course, anytime during the Q&A section through the Q&A function or the chat function at the bottom of your screen. And please also indicate whether your question is directed at a specific speaker or the panel as a whole. And Rouven and I will then forward your questions and collect them and post them to our panelists in due time. And before we begin with the presentations, our Institute's Executive Director, Professor Pierre Thielbörger, will set the stage with a few introductory remarks. Professor Thielbörger is a professor of German public law and public international law at Ruhr University Bochum and chair of the European Society of International Law's Interest Group for International Human Rights Law. Pierre, you have the floor.
Yes, thank you, Lisa and Rouven, for the introduction. I was asked to keep it very short, which I will gladly do, but at least I want to say 2 words of thank you. And that is really on the one hand to ESIL, who's co-sponsoring this event, in particular the Interest Group on International Human Rights Law. We've had a series of events, a series of events in the last weeks, and they have all been really great. And it's been a pleasure to work as a co-chair of this interest group. So to all members of the interest group on international human rights law within the European Society, welcome. And if you don't know what the European Society of International Law is, get to know it, go on the website. It's an amazing society. And if you're interested in international law, you should join. Secondly, I would like to thank everyone within the Institute for the International Law of Peace and Armed Conflict, as Lisa and Rouven have already said, which is one of the big international law institutes in Germany. And I'm quite impressed by the 2 events that the 2 of you have put together, Lisa and Rouven. So compliments. I mean, if people even get up in Melbourne for events like this, that is, the biggest compliment you can get. So just maybe 2 minutes or so on as an introduction for those who are not so deep into the topic, as our 3 distinguished speakers, of course, are. I was thinking, we've had now 1.5 years of pretty heavy restrictions, probably in many ways unprecedented restrictions. And now we have a new time, now we have a new era, because all of a sudden we see that these vaccines kick in, and many of them seem to be highly effective. And while, of course, the lack of the vaccines was problematic, very interesting topic, which we had a seminar on last week, where we discussed the vaccination gap, why the global south doesn't get enough vaccines, and how we look at that from a human rights perspective, how we look at that from an intellectual property perspective. Of course, interestingly enough, also having vaccines also triggers human rights issues, and that's really more what we are dealing with today. Let me highlight maybe 3 of them, and they, I think, correspond quite well with the 3 topics we will discuss as well today. So one is, of course, compulsory vaccinations. Obvious problematic if you think about human rights, such as physical integrity or the respect of private life. And I want to tell some of you, if you haven't read it yourself in the news, remind you of how extreme the idea of compulsory vaccinations can get if we think about an example from the Philippines, which was in the newspapers recently, where President Duterte has threatened to arrest all Filipinos who refuse to get vaccinated. Right? He, in very strong language that I will spare you now, but he essentially called on all Filipinos to leave the country if they were not willing to get vaccinated. So we don't want you as a citizen anymore, or as an inhabitant anymore, if you refuse, right? So, and that seems a bit extreme, but also if you look into European countries, there's a quite clear divide. Germany, for instance, has categorically excluded the possibility of mandatory vaccinations. Italy has made them already, has already done them, in particular for healthcare workers. And the French government has announced recently that they would consider them if the willingness to get vaccinated remains low in France. Yeah? So also in the European Union, this is a very important topic where states have different opinions on the matter. And with this new variant on the rise, I think these questions will become more and more prevalent in the next weeks. The second issue that comes to my mind when I think about this is that of social media and fake news. So the more successful the vaccines became, the more we knew, okay, there would be vaccines, the more there were also stories about whether they were dangerous. There were some funny ones. I read once that some people claimed that it was all Bill Gates who was using the vaccines to implant monitoring devices into billions of people. But, there's also more, less, if I may say, ridiculous stories about them that are spread via Twitter, Telegram, and other social platforms. For instance, there is the claim that the new technology, this mRNA technology, BioNTech and Moderna are using it, would alter the human DNA, and that it could cause illness, infertility, death. Yeah? So these are stories that are around and that many people believe in. And then the question is, how do we deal with these? Where do we draw the line if these kind of stories are spread without having any scientific basis, or maybe they do? And so the big question here is, how do we balance these fundamental values of our societies? On the one hand, the freedom of speech, which is a very high value that we honor, but on the other hand, also, of course, the protection of public health. Third and last point from my side is, once a person got vaccinated, how do we deal with these people? Do they get additional rights? In the German discourse, these were very unfortunately phrased as privileges. So the privileges of the people who would get vaccinated. Think, for instance, about the EU COVID certificate that is discussed, which would allow you to travel again safely and freely within the European Union. That might not be the only way how you can travel within the European Union, but it makes this travel for people, for their holidays, for transnational families like I'm part of, a lot easier. Yeah? So how do we deal with this from a human rights perspective? How can we align the different human rights here of people who maybe are not willing to get vaccinated or not able to get vaccinated because the rates in the countries are very different so far. And of course, if you think about such a COVID passport, a COVID certificate, if you like, also a very other issues arise, for instance, in the field of data protection. Right? Sensitive personal information will be on these vaccination passports. And, the EU is very big on data protection, has many rules on that. So there is the question whether all of this actually is in compliance with the rules that the EU has set for themselves. So these are just examples to go to show that it's not only a question, what do we do if we don't have vaccines? It's equally a human rights question, what do we actually do with a situation where we do have vaccines? Or where people don't want to get access to the vaccines, although we don't have it. So I think this is this is it from my side. I hope this has set the stage a bit. I think our three distinguished callers are in an excellent position to answer the three topics that they have suggested. I have read also their pieces. Some of it has been published. And so I'm really looking forward to our first speaker, which to my understanding is Sissy Katsoni. Thank you very much for the few minutes of time.
Well, thank you, Pierre, for indeed setting the stage so perfectly, and for your introduction, which made us all the more eager to dive into the presentations and discussion. So without further ado, let me welcome the first panelist of today's webinar, Ms. Sissy Katsoni. Sissy is a PhD candidate and a research associate at the Institute for the International Law of Peace and Armed Conflict. She holds an LLM from the National and Kapodistrian University of Athens, where she's also read law, as well as an LLM from the University of Groningen. Sissy has published on the topic of compulsory vaccinations on numerous occasions, and therefore, Sissy, we are looking forward to your remarks. The floor is yours.
Thank you very much, Rouven, for the kind introduction. You know, it is a great pleasure for me to be in the panel as well. So today, I would like to start, first of all, by sharing my screen. And yes, I guess you can see it, right? Great. So I will seek to draw your attention today to the issue of compulsory vaccinations and the human rights implications thereof. Right at the outset, however, I should point out that on numerous occasions, several WHO officials have underlined that the measure of compulsory vaccination should be avoided and that states should rather focus on persuading the public on the merits of the vaccines instead. However, what happens if a large percentage of a state's population refuses to get vaccinated? Or what happens if a large percentage of the state's healthcare workers refuses to get vaccinated? It is such issues that bring discussions on compulsory vaccinations back to the front line, and along with them, of course, come discussions on the human rights implications of the measure. It is to this precise issue that I will turn, and I will use the term compulsory vaccinations during this presentation to define a measure according to which a state requires those within its jurisdiction to get vaccinated against COVID on pain of a penalty. Now that having been clarified, I would like to invite you to question with me the compatibility of this measure with human rights law. So far, the Inter-American Commission on Human Rights is the only human rights body that has addressed the topic. Precisely in a resolution issued last April, it noted that all COVID vaccinations that states administer must be subject to the free, prior and informed consent of the individuals being vaccinated. Against this background, and given that the Inter-American Commission is the only human rights body that has addressed the topic, this could be the beginning and the ending of this presentation, considering that it is rather eloquent in its report, in its resolution, showing that it rejects the measure as incompatible with the human rights standards of the Inter-American human rights content. However, the ECHR institutions have also addressed the topic in their jurisprudence. And spoiler alert, the jurisprudential examples, indications of the ECHR seem to be pointing to a slightly different direction. So as early as in 1984, the European Commission on Human Rights underlined that a requirement to undergo vaccination on pain of a penalty may amount to interference with the right to respect for private life. Later on, the court verified this vaguely phrased assumption and noted that compulsory vaccinations amount to an interference with Article 8 of the ECHR. Now, last April, in the very already famous Vavricka and others versus Czech Republic judgment, the Grand Chamber moved a step further and noted that the mere vaccination duty, even before the vaccinations take place, constitutes an interference with Article 8 of the ECHR. Against this background, there seems to be no doubt as to the fact that compulsory COVID vaccinations would be also seen as incompatible with the ECHR. And against this background, what should be further assessed is whether this interference can be justified under the limitation clause of Article 8. In this regard, and provided, of course, that the measure is prescribed by an accessible and foreseeable legal provision, what should be questioned is whether the measure of compulsory vaccinations pursues a legitimate aim. in all of the jurisprudential indications that I talked about earlier, the European Commission, the European Court of Human Rights, accepted that the measure of compulsory vaccinations pursues the legitimate aim of the protection of the health of the public and of the persons concerned. So against this background, there seems to be no doubt as to the fact that it would also find likewise in the context of the pandemic, for which the measure of compulsory vaccinations would be introduced. So in this sense, what will in fact be the decisive factor as to the measure's compatibility with the ESIL is the very last question indicated in the slide concerning the necessity of the measure in a democratic society. Now, in its jurisprudence, in its decisions, the Commission and its judgments, the Court had elaborated certain criteria on the assessment of the necessity of compulsory vaccinations in a democratic society. But last April, the Court further elaborated this criteria and shed further light into their scope. So it is against this background that I will proceed with the presentation. And so while assessing the compatibility of compulsory children's vaccination with the ECHR in the Vavritsky judgment, the Grand Chamber noticed firstly that states enjoy a margin of appreciation with regard to healthcare policy. And in fact, it found that this margin of appreciation was a wide one. In this regard, it noted firstly that domestic authorities were best placed to assess priorities, and it further underlined the value of social solidarity and the duty to protect the health of all members of the society. Precisely, in its judgment, in its analysis, the Court noted that in such situations, some of us may need to undertake the minimum risk of vaccination in order to protect other members of the society, which are more susceptible or vulnerable with regard to certain diseases. So, but on a more technical note, to conclude that the margin of appreciation was a wide one, the Court underlined, firstly, that there was a consensus among ECHR states and international bodies as to the value of vaccinations and successful and cost-effective health interventions. And secondly, that there was no consensus among ECHR states over a coherent policy on children's vaccination. Now, this pattern, which led the Court to conclude that there was a wide margin of appreciation and that the measure of compulsory vaccinations fell within that margin, is also spotted in the case of COVID vaccinations as well. As Pierre noted in his introductory comments, some states have already implemented the measure of compulsory vaccinations, whereas other states have are still considering it, especially now that they get access to more sufficient numbers of vaccines. On the other hand, we all know that there is a consensus with regard at least to the value of the vaccines as cost-effective and health intervention, as all states try to get access thereto. So in this sense, this pattern that led the Court to reach this conclusion is also met in the case of compulsory of COVID vaccinations as well, and therefore this first criterion seems to be also met in the case of compulsory COVID vaccinations. Against this background, we should move to the second criterion assessed by the Court, which was the existence of a pressing social need and relevant and sufficient reasons necessitating the implementation of the measure. In its analysis, the Court underlined that the compulsory vaccination of children was introduced for the prevention of a downward trend in the rate of vaccination, which was important for the maintenance of herd immunity. Now, from my point of view, this judgment, the Vavritsky judgment, can serve as the basis of an a minore ad maius argument. If the Court was ready to accept that the measure of compulsory vaccinations was indeed implemented for the purpose of addressing, for the state to address the relevant pressing social need, the situation that we are currently going through, a pandemic, in the context of which we have yet to achieve the required herd immunity, I think it would not find otherwise. But in any case, the Court also noted in its judgment that when a voluntary vaccination policy is not considered sufficient for the achievement of herd immunity, or when such immunity is not important, then domestic authorities may reasonably introduce compulsory vaccinations policy. From this point of view, the second criterion seems to be also met in the case of compulsory COVID vaccinations, and therefore, what is in fact the decisive factor with regard to the measure's compatibility with ECHR is the stricto sensu proportionality of the measure with the legitimate aim pursued. In this regard, having to assess the proportionality of compulsory children's vaccination, the court in the Wawrzycki judgment noted that vaccination was considered effective and safe by the scientific community, that vaccinations were not forcibly administered, but rather only indirectly enforced through protective sanctions, that the national authorities were cautious of contraindications before each vaccinations, and that the safety of the vaccines was monitored, as well as the fact that the national law provided for exceptions in cases of contraindication or conscience, as well as for compensation for injuries caused by the vaccine. After all, the court pointed out that the existence of less prescriptive alternatives was not central for the measure's proportionality with the legitimate aim pursued. And so, from this point of view, drawing exactly on these guidelines set out by the court, we can conclude that at least under the following conditions, the measure of compulsory vaccinations will be proportional to the legitimate aim pursued. This would be the case if compulsory vaccinations are, the vaccines are considered safe by the scientific community, and if the safety of the vaccines is monitored, if they're not forcibly administered, but only indirectly administered through protective sanctions, if the national law allows for exceptions in cases of contraindications and conscience objections, and if compensation is rendered available in situations of injuries caused by the vaccine. Under at least these circumstances, the measure will be seen as proportional to the legitimate aim pursued, and therefore necessary in a democratic society, and therefore as a justified interference with Article 8 of the ECHR. So thank you very much for your attention. I'm pretty sure that I hope I didn't bore you too much with your presentation, but I'm pretty sure that the subsequent rounds are going to be very interesting. So I will now stop and I'll let you guys go ahead with your presentation as well. Thank you.
Yeah, thank you, Sissy, for your insightful presentation. I'm sure that we will have a lot to discuss also during the Q&A section. I think it's very interesting that there's not much jurisprudence on mandatory vaccinations, even though, as you have shown us, for measles, for example, there are already compulsory vaccinations in place. And we'll see how that turns out to work with COVID-19. And even though there are not many mandatory vaccinations for COVID-19, we will see the EU digital COVID certificate entering into application in 2 days, this Wednesday. And I think that it will incentivize a lot of people to get vaccinated, and maybe even the promise of traveling more freely will maybe come somewhat close to mandatory vaccinations. So let us now continue with the second input for this webinar by Professor Iris Goldner Lang. Iris is the Jean Monnet Professor of European Union Law and holder of the UNESCO Chair on Free Movement of People, Migration and Intercultural Dialogue at the University of Zagreb, Faculty of Law. She's president of the Croatian Society for European Law, the Croatian representative of the Odysseus Monnet Network for Immigration and Asylum, and the editor-in-chief of the Croatian Yearbook of European Law and Policy. She is a leading scholar in European Union law, particularly in the fields of migration and asylum law, free movement, and health law. Iris, we're very much looking forward to your remarks, and the floor is yours.
Thank you so much. Thank you, Lisa. So before I start, just of course, I would like to thank the organizers for the invitation, and my special thanks goes to Lisa and to Rouven for the organization and for making use of the Zoom world that we all live in these days. So thank you again. Now, what I will do, I will share my screen with you. Okay, can you see it? Great. So as Lisa mentioned, so my plan is to talk about the pros and cons of the EU COVID certificates. And in the next up to 15 minutes, I will just briefly mention what COVID restrictions have been imposed by EU member states, which have impacted the cross-border movement within the EU. I will then move on to the issues of the question of justification and proportionality of these measures, and I will rely on my text, on my paper, Laws of Fear in the EU, which was published last year in the European Journal of Risk Regulation. And then the core of my presentation will be on COVID certificates, what I will be talking about today will be published probably within the next 2 weeks, again in the European Journal of Risk Regulation, under the title of EU COVID Certificates, a Critical Analysis. Now, as regards the measures that have been imposed by EU member states as a response to the pandemic, in the area of free movement, we can group them into 2 different categories. The first one have been border checks on intra-Schengen borders, and the second group, which I find even more interesting and more even visible, I would say, have been all sorts of travel restrictions. At some point, certain member states imposed complete entry or exit bans, quarantines, self-isolations, tests, and so on. What the end result of all these measures has been was a very diverse and very inconsistent situation in terms of free movement within the EU. So there was simply a complete lack of coordination, because all of these measures, with the only exception being the introduction of the external border controls towards third countries, all the other measures have been imposed by EU member states without being first coordinated, discussed, and agreed at the level of the European Union. Now, and I will explain the novelty that COVID certificates bring in this regard in a moment. Now, moving to the second point that I would like to raise, have these measures really been justified and proportionate? Now, when it comes to justification, of course, all these measures were based on public policy reasons. And here, what I find particularly interesting is that when it comes to the reintroduction of the temporary introduction of internal border controls within the Schengen area, the Schengen Borders Code does not mention with one single word a possibility to reintroduce internal border controls for public health reasons. So it's simply not there. The only reasons that can be relied on to reintroduce Schengen border controls are public policy and public security reasons. So we can either state that what has been done has been contrary to the Schengen Borders Code, or we can say that the threat of the pandemic was so huge that it amounted to public security or internal security threat as well. On the other hand, free movement can be limited due to public health reasons. However, over the past decades, public health reasons were basically very rarely used to limit free movement. And I looked at some older documents of the Commission that have been written several decades ago, where the Commission stated that public health justifications are simply outdated. As we can see today, this is not the case, obviously. So we can see the pandemic as a kind of a regeneration of public health restrictions, of restrictions which are based on public health reasons. And what I find particularly interesting is that the pandemic has shown that we can rely on public health reasons in very different situations when compared to other justifications, public security and public policy ones. Why? EU law has taught us over the years, as interpreted by the Court of Justice, that we can rely on public policy and public security reasons only when there is an So we need really to apply an individualized risk assessment and say that that particular individual, due to his or her own behavior, represents a threat to public policy and public security, and that for that reason, his or her movement can be limited. On the other hand, COVID-19, due to the symptoms it has, and due to the way it is transmitted and it spreads, could not rely on such individualized risk assessment, at least at the very beginning of the pandemic. So the restrictions that have been imposed have been very general, very systematic. They've encompassed hundreds of thousands of individuals. Yeah. So what we have seen due to that is that there is an increased difference, a kind of a gap between situations which rely, or restrictions which rely on public health reasons on the one hand, and public policy and public security reasons on the other hand. And I would like to use this in a moment when I talk about COVID certificates to show that COVID certificates have actually enabled a little bit more individualized risk assessment that when compared to the situation before the application of COVID certificates. Now, as regards proportionality, I would say that some of the measures that had been imposed over the past year have not been really proportionate. Some of them have not been suitable, some of them have not been necessary. On the other hand, what I would like to point out here is that because of the use of the so-called precautionary principle, and I've provided the definition of the principle here. It's a principle which enables decision makers to adopt restrictive measures when scientific information is insufficient or uncertain and risk to human health is high, that due to the precautionary principle that has been relied upon when imposing anti-COVID measures, the threshold for the application of the principle of necessity has been kind of lowered. Why? How can we really know if we are not sure scientifically about the disease, whether the same level of public health protection could have been achieved by a less restrictive measure? It's very difficult. So because of the fact that there have been so many scientific unknowns linked to COVID-19, the result has been that really sometimes it's very difficult to prove that a less restrictive measure could have protected public health equally successfully. Now, as regards the COVID certificates, as we all know, they are going to enter into force in a couple of days. So on the 1st of July this year. And what is important and what has been repeated so many times in the public, but I think it's really important again to stress this, COVID certificates are not only about vaccination, which is very important. So they kind of comprise 3 types of certificates: vaccination certificates, recovery certificates, and test certificates. And here I would like to mention just 4 pros and cons, which I find particularly important, but there are more, of course. So the first thing that has been emphasized by the European Commission has been that digital COVID certificates will enhance cross-border movement within the EU. And that's absolutely the case. It is going to help. Now, the Commission also said that it's going to enhance safe cross-border movement. And the word safe here kind of comes into the spotlight. Now, I absolutely am conscious of the fact, and I really do believe in vaccination. I've been vaccinated myself. So I'm sure that vaccination does help in minimizing the risk of transmission. However, I would like to point out that there are still certain scientific uncertainties linked to this question. Why? Just to quote what the International Health Regulations Emergency Committee has recommended to the WHO state parties. They stated not to require proof of vaccination as a condition of entry, given the limited, although growing evidence about the performance of vaccines in reducing transmission and the persistent inequality in the global vaccine distribution. And this was from the 19th of April this year. So 2 months. I think that as time goes by, there is more and more evidence that vaccines really do minimize the risk of transmission. That's undoubtable. However, there are still a number of open questions with regard to new variants of the virus and different efficacy of different types of vaccines. And if we look at the digital COVID certificates regulation, Article 5 states obliged to recognize vaccination certificates of the 4 vaccines that have been authorized at the level of the EU. Fine. However, on top of that, EU member states can also recognize vaccination certificates of people who have been vaccinated by vaccines which have not been authorized at the level of the EU. And this has been the case, for example, in Hungary, where a lot of people have been vaccinated by Russian. And if we do recognize such vaccines, such types of vaccines, are we really, and to what degree, talking about safe cross-border movement here? And I'm sure that some countries, for example, my home country, like Croatia, will, due to tourist reasons, recognize such certificates because they will want to attract as many coasts as possible. Now, moving on to the second pro and con. So, digital COVID certificates preclude more restrictive national measures. And that's good. So, they do enable a more individualized risk assessment. Why? Because if a person has been vaccinated, he or she does not need to undergo self-isolation, quarantine, or do a test. So in that sense, if you compare this situation to the one that I talked about several minutes ago, COVID certificates contribute to more individualized risk assessment, and that's good. They also, what I believe, do, they disable a kind of a race to the bottom out of solidarity towards the non-vaccinated ones. And here I would like to refer to what Pierre was talking about at the very beginning, at the introductory part, that there is a question whether vaccines are really fair. And I will talk about fairness in a moment. However, what I would like to point out is that the solution will be vaccinated while others will not be vaccinated is not the race to the bottom, is not to say, okay, we are not going to recognize any vaccination certificates out of solidarity towards those who cannot or do not want to get vaccinated. Why? Because that would be contrary, first of all, to the principle of proportionality. That would mean that we would be imposing more restrictive measures on people who have been vaccinated, because we would ask ever, and that's probably not necessary. And also, I think that this would kind of simply be unnecessary to simply say, okay, everybody needs to be tested. That's not the right answer, because the alternative to COVID certificates is not free movement. The alternative are even harsher restrictions. Now, what is the con of COVID certificates in this regard? If you look at the regulation, it says that member states will nevertheless be able to impose additional restrictions. So why do we have that, even though the European Parliament insisted to move this out of the regulation? Member states would not accept. I see this as a kind of a compromise with certain member states who would otherwise not be ready to adopt the regulation. So it will still be possible in certain cases for member states to impose more restrictive measures. However, in that case, again, they will have to prove that these measures are justified and proportionate. The third pro and con. Digital green certificates do not discriminate times. Why? Because there are alternatives. People can get tested and people can prove that they have recovered from COVID-19. I would agree with them. I would say that the fact that there are alternatives creates, yes, it does create an additional burden on those who have not been vaccinated in the sense that they need to get tested. But I would say that the burden is not disproportionate. What is important is that everybody who wants to get vaccinated has a chance to do so. Otherwise, there would be a social perception of unfairness of these certificates. So it's important that we don't have a case where half of the population cannot get vaccinated because not that they are not allowed to do that, but simply because there are not enough vaccines. The only thing that I would like to point out here, and I'm not going into the detail, but we can talk about it in the discussion part, is that I believe there are exceptions when compulsory vaccination can be imposed. And that applies to certain high-risk jobs, like jobs in hospitals and nursing homes. Why? Because here public health benefits would outweigh individual rights, and it would be perceived as ethical by the majority of the population. And I would compare this to the situation of a pilot. It's okay to ask from a pilot to have perfect eyesight. Even though it discriminates for that type of a job, everybody who doesn't have a perfect eyesight, including myself. But it is accepted, it's acceptable, because of the benefits and the risks of that job that job would create if you would allow people who do not have perfect eyesight to work. Finally, and my last point, COVID certificates have a coordinating effect. I mentioned at the very start of the presentation that what we had was a complete chaos, and COVID certificates would improve the situation. They would enable similar national cross-border mobility restrictions, and they would also have an even wider effect in terms of the coordination. Why? Because a number of member states have already imposed or were thinking of imposing their national COVID certificates, like Denmark, for example. And what will be achieved by EU COVID certificates, that will be that all these national certificates will be harmonized. And that's, I think, a very positive thing. Now, what is important here is that national COVID certificates are not about cross-border movement. They're about access to certain social, cultural events and so on. And they are based on national law. Whereas EU COVID certificates cover only cross-border movement issues, and they are based on EU law. But these two will be coordinated, and that will be the positive effect. To conclude, COVID certificates will be valid for 12 months. What will happen then, nobody knows, because we don't know whether this will be the end of the pandemic, due to the fact that nobody is really sure what is the percentage of the population we need to create herd immunity. Is it 70, 80, 90%? Nobody knows for sure. Now, what are the lessons of COVID certificates, even though we have not really started applying them in complete? I think that the process that that has been happening over the past years is a process that I like to call contestation and accommodation. Why? The first several months of national restrictions have been a contestation of everything, of EU free movement law, of human rights, of everything. And then later on, after several months of these contesting measures, what we are viewing now, and COVID certificates come in that group, are measures of accommodation, measures where the EU is trying to accommodate EU free movement law within the pandemic times. COVID certificates have also emphasized the need of coherence between the EU and member states' actions. And finally, COVID certificates have really shown that there is a really thin line between the EU and member states' competencies in healthcare. Why? For the simple reason that COVID certificates, as I mentioned a moment ago, will have a coordinating effect on national COVID measures, which are not really about free movement. So thank you very much for your attention.
Well, thank you, Iris, for this really interesting presentation and for giving us a lot of food for thought, which we can get back to during the Q&A section. Now, as you all know, there are those who won't even be nudged towards getting vaccinated by these COVID certificates, but who rather actively oppose COVID vaccinations. And that brings us to the third presentation for today by Professor Marko Milanovic. Marko is Professor of Public International Law at the University of Nottingham School of Law. He serves on the editorial board of the European Journal of International Law and its internationally renowned blog, ESIL Talk. Marko has acted as counsel or advisor before various international fora, for example, the International Court of Justice or the European Court of Human Rights. Marko is renowned for his expertise in international law, particularly human rights law and human rights in the digital age. Marko, we are looking forward very much to your remarks. The floor is yours.
Thanks, Rouven. It's a great pleasure to be with you, and thank you very much for inviting me. And the topic of my talk will be vaccine misinformation and how vaccine misinformation is sort of seen and regulated under international human rights law, and particularly with regard to the freedom of expression. So let me sort of start off with a very brief terminological point. If you look at the literature, especially in the online context that discusses this question of false information about vaccines or any other topic, it's very common to distinguish between disinformation and misinformation. Disinformation being an intentional act of spreading false information with the purpose to mislead or cause some kind of harm. Misinformation being the unintentional, innocent spreading of false information. So I don't know, I mean, if you have some kind of anti-vaxxer activist who knows that what they're speaking is false, yet wants for the purpose of making money, for example, to spread false information about vaccines, that would be disinformation. Whereas if your mother, grandmother, father, whoever, you know, texts you something about COVID and garlic and vaccines, they are doing that out of good intentions. They want to help you, right? It's just that they have been misled into believing something that is false. So that's often the distinction that's used in the literature. However, for our purposes, for legal purposes, it's actually not entirely useful, because the distinction between innocent and intentional is actually far too crude for legal purposes. And we know many, for example, gradations of culpability in law that may have a bearing, some bearing here. And because the same item of information that is being spread by some person with intention, by some person innocently, can be disin or misinformation depending on how you want to see it. So I will tend to use the term misinformation in a generic way as encompassing any kind of false information about vaccines. This is, by the way, I'm talking on the basis of a project I have done with my colleague Filippo Webb from King's College London. We have been working on a big paper for the high-level panel on media freedoms that was established by the UK and Canadian governments, and that report will be coming out in September, but it deals with all kinds of misinformation, disinformation, not just the vaccine related. Anyway, so what does international law, specifically human rights law, have to say about this? Well, there are two key questions we must ask in that regard. The first question is, who is spreading the disinformation or misinformation? Is it the state or a state, or is it some non-state actor? The reason why the question is central is because the obligations that international imposes on states are different, depending really on who the originator of the false information is. And international law is essentially a state-centric system. So that who question is the pivotal question in the entire mis or disinformation debate. Who did it? The second who question is, who is responding to it? Who is regulating it? Is it the state that is trying to deal with the problem of misinformation? Or is it, again, some kind of non-state actor that is trying to do that? In our particular context, that non-state actor will be some kind of dominant digital platform through which misinformation is being spread, like Facebook, which is actually in a place to essentially regulate this kind of activity, sometimes with, but most often without state input. So the issue is, from their perspective, how should they internalize human rights in their own decision-making, right? So that's two different who questions. And then a third question that I will spend some time on, probably more briefly, is what are the standards that govern this kind of regulation materially or substantively? So whether it's the state or a corporation that is regulating this type of false speech, how should they do so, right? What does international law have to say on that? So let me turn first to that first who question of who is doing it. If a state is spreading misinformation about vaccines, in doing so, it can do that either against its own population, which is more common, or against the population of some other state. Unfortunately, we have witnessed many high-level officials all over the world spread various kinds of false information about COVID and about vaccines, whether it's Trump or Bolsonaro or whoever, or my favorite example, the now dead president of Tanzania, President Magufuli, who really did a buffet of misinformation about COVID. There wasn't a single sort of lie that he did not use, from doctoring numbers, denying that there was COVID in Tanzania, from prohibiting officials of acknowledging the disease, from telling people to use steaming and herbal medicines instead of whatever they have, from casting doubt on vaccines and masking, and in the end he got COVID and died. So he's a happy example, sort of, in a sense, but the problem with state misinformation is that actually it outshadows, it vastly outweighs the harm that is caused by non-state actor misinformation. Again, if you look at the harm to public health that has been done by some of these public officials, it's way worse than whatever happens on Facebook, right? So that issue, state misinformation or disinformation, can harm the right to health of people. It can harm their freedom of expression in that aspect of seeking and receiving information. It can harm their freedom of opinion. It is designed in such a way to manipulate people and to deny them the autonomy of making their own decisions. So that is state misinformation as a denial of human rights. And an even more interesting example, slightly less common, is when states do that against some other state. So it has been reported, for example, that Russia has engaged in a misinformation campaign designed to discredit the AstraZeneca vaccine. Okay, so there's a recent article in The Guardian, for example, that documents some of these allegations. That, for geopolitical reasons, Russia has mobilized various kinds of actors to overplay the risks of the AstraZeneca vaccines and to overplay the benefits of the Sputnik vaccine that Russia has produced. Whether this is true or not, I don't want to get into that. I have no idea, right? But it's if a state does that, right, again, you have the possible violations of all these human rights that I have just mentioned. There is this added problem of extraterritoriality, however. Does Russia owe human rights obligations, for example, to the people of the UK when it is launching in that type of disinformation campaign? I'm not going to spend any time on that issue, but be aware of it. Okay. Now, that's state disinformation or misinformation as a violation of human rights. If a non-state actor or actors are doing it, especially in an organized way, the state has a different kind of obligation. It's an obligation to protect its own population, specifically the right to health of its people, to protect the information space, to protect their ability to seek and receive correct information. And the issue then is, what measures should the state take to actually deal with that kind of harmful content that is being spread, for example, online. The same dilemma, of course, is the one that digital platforms find themselves with. On one hand, they have a duty, in a sense, towards their users to protect their right to health and to protect the integrity of vaccine programs. On the other hand, what about the freedom of speech, the right of all these people to say whatever they want to say, sometimes believing that sincerely, right? So there are some anti-vaxxers who deliberately manipulate people with, for example, profit making as their primary motive. But then you have anti-vaxxer activists who genuinely believe that vaccines of all kinds are harmful. As we know, anti-vaxxer ideology and messaging did not start with COVID vaccines. It has a much older roots, and in the online context, of course, has proliferated, especially with regard to childhood vaccinations and putative links between vaccines and autism. So that's the big question. How should states regulate the information space, and how should digital platforms in the online context do so in order to combat the effects of vaccine-related misinformation? When it comes to corporate entities, they are not, of course, themselves directly bound by human rights, including the freedom of expression. But as you know, within the UN, there have been decades of work culminating in the UN Guiding Principles on Business and Human Rights, which sort of try to internalize within corporate decision-making some human rights principles, even though they were designed for states in a more adapted form that is usable for corporate, if you will, self-regulation. And in fact, if you see what Facebook, Twitter, and others have done, they have progressively done so. They have progressively adopted human rights policies and language as part of their own regulatory framework. And in fact, now they have cracked down on vaccine-related misinformation more and more severely in the wake of the pandemic. Facebook in particular has done so from March this year onwards. Although, of course, you can always argue that they have done so far too late. Now, the issue is what kinds of regulatory interventions would satisfy the basic human rights justifiability test for interfering with the freedom of speech. So as you know, in order to interfere in a justifiable way, the freedom of expression, the restriction must be provided for by law, it must pursue a legitimate aim, and it must be necessary and proportionate. On the provided for by law kind of prong of the test, the problem is that many laws that deal with health-related misinformation are overly vague and generate chilling effects. That's especially the case when you have criminal laws that do that. Quite a few states have now passed laws that criminalize the spreading of COVID-related disinformation that can be used, for example, to prosecute people who criticize the government's response to the pandemic in a way that is really far too broad and, again, far too vague. The issue of legitimate aim is easy in principle, in the sense that we will all agree that regulating false speech about vaccines protects the purpose of protecting public health, which is expressly stated in all of the relevant human rights instruments. The key issue here, though, is that some states are actually acting with ulterior purposes. So they are saying that what they're doing is they're trying to protect public health, But in fact, what they're doing is they want to suppress criticism of the government. They want to suppress political pluralism and dissent. And you have examples, from Europe, I don't know, from Hungary and Serbia to Russia, to countries all over the world that have used essentially the pandemic as a pretext on clamping on all sorts of types of political rights, from the freedom of assembly to the freedom of speech. So the issue is, can you prove that such an ulterior purpose exists? And if you can prove the existence of that type of purpose, essentially the state's regulatory measures would fail the justifiability test under human rights law. So far, in the European Court of Human Rights context, for example, there have been very few cases where such ulterior purposes have been found, but the court has been doing that more and more frequently. Recently, for example, it has found that various measures that Russia has taken against Alexei Navalny, or the arrest and detention and trial of Selahattin Demirtas, the Turkish Kurdish opposition leader in Turkey, were motivated by such ulterior purposes, the suppression of political dissent. So it can be done, and the European Court at least has found that that states have acted with such purposes. The biggest problem, of course, will be the necessity proportionality analysis. Here, the key thing that I can say is this: it is much easier to justify various forms of content regulating measures or content moderation measures, which themselves can vary on a spectrum from, for example, labeling certain content as false, promoting more accurate content like authoritative sources of information such as the WHO, to more severe restrictions such as the suspension of accounts or the deletion of specific messages, okay? Those types of measures are much easier to justify than repression through criminal law, okay? So if states want to resort to regulating COVID and vaccine, specifically vaccine-related misinformation through criminal law, that can only be done in a very, very exceptional way, subject to very strict requirements of culpability and causation, meaning that you can prove that the person knew that the information they were spreading was false, and that they intended to cause some harm, and that there is a strong causal connection between the false speech and the harm. Okay, so that's the key issue of rigorous causal and culpability requirements in the criminal law context. But again, it is much easier to justify various other types of regulatory measures that digital platforms, for example, have already been using. The biggest problem, however, is that none of these types of measures are by themselves effective. What you need to do, and what many states have failed to do, is organize a comprehensive campaign across many, many different lines, using many, many different tools, relying on literature in communication science and social psychology, et cetera, to persuade people that vaccines are safe and effective, and to counter the false narratives that are being spread by people who do so either intentionally or innocently. Okay, and that is and that includes everything from digital literacy to literacy in the basic sciences to again promoting authoritative non-political voices that can convey such messaging. And if you look at places where vaccine misinformation is proliferating, it is precisely in those places that the state has failed to take that proactive step which it needs to take before resorting to restricting speech. So that's it from me. Thank you so much.
Yes, thank you, Marko, for this engaging presentation, I might say, and also the reminder that, the issue of vaccine misinformation is certainly not new, but has been there even before COVID, and it's not exclusive to COVID vaccinations. And really helpful to pick apart the different actors and actions, and the lack of effective measures to tackle that problem. So thank you very much. And yes, with that being said, we would like to now kick off the Q&A section of this webinar. So again, feel free to continue posting questions through the Q&A section or the chat function at the bottom of your screen. And for the first question, I would like to give the floor to Pierre.
Thanks. I'm abusing my position here that I'm one of the few with a camera where I can raise my hand. When I was listening to your presentations, I was thinking about a combining factor in all of them. And I think when listening to Marko now, it's become very clear to me which one of them is, and that is the role of non-state actors, in particular businesses. So you might be aware that, these days, I don't know, actually maybe today, one of these days, it's the 10 years anniversary of the United Nations Guiding Principles on Business and Human Rights within the United Nations. We had a big event with John Ruggie last week within the Interest Group of ESIL and within the Institute. So my question is, so when I think about the role of private businesses, sorry, that's my daughter. When I think about the role of private businesses in all of what you have told us, so Marko has talked about that, states can do more harm than businesses in his field, but still businesses have a particular role to regulate what kind of disinformation or misinformation is spread or is not spread. When I think about Sissy's presentation, I think about employers who have famously stated they would make vaccinations mandatory, and these are not like some strange employers with weird political opinions. Harvard University has also announced they would make vaccinations for all their employees mandatory. When I think about the role that private companies might have in ensuring the free movement of people within the EU. So my question is broadly speaking about the role of businesses in this. Do you think this whole pandemic, COVID-19, has kind of disclosed new obligations or at least responsibilities of companies vis-a-vis human rights protection? And would you say that the regime of business and human rights, which is an evolving regime, as you know, right? Because obviously, traditionally speaking, corporations do not have human rights obligations. Do you think that this whole thing has kind of strengthened this idea? Because the responsibilities of companies have become so clear over the last month in all three of the case studies that you have kind of introduced us to. Thanks for trying to answer. Whoever wants, it's a question to all.
Well, I could go ahead and start if the rest of the panelists wouldn't. So first of all, the Inter-American Commission in its recent resolution that I talked about, resolution number 1 of 2021, noted that states must require businesses to include workplace vaccination as a collective measure of protection and reporting in the vaccination programs they establish in their businesses. And it further underlined that the effective implementation of these duties impacts businesses, even when states are not complying or not adequately complying with their obligations regarding the COVID vaccines. But then we know that the resolutions of the Inter-American Commission are also not binding. So, but at least we see that the Commission would like to promote this in its report, although it doesn't, again, specifically note which provision it is interpreting and under which provision it seems it reads this obligation of states and of businesses. But at least we see that there is an intent, and I think that is something interesting. But on the other hand, with regard to the issue that you referred to, with regard to dismissals concerning on grounds at least of non-vaccinations, I think that first of all, I have written a blog post, which is already a blog, it's not the Frederick's blog, and I will post it in the comment section below, read it. But aside from that, well, the UN Committee on Economic, Social and Cultural Rights has warned that public health considerations can serve as the basis for differentiated treatment at work. And there are already pending cases on the matter. To my knowledge, there is a pending case before the US District Court of New Mexico. It's a case filed by a detention center official who was fired because he refused to get vaccinated. And I think that First of all, we do not have jurisprudential indications at this point. We don't have decisions, ad hoc decisions in the matter, but there is a judgment which, to my very best knowledge, was the only judgment that could be parallelizable, that we could extract conclusions from. That was the IB versus Greece judgment of the European Court of Human Rights, again, in which an HIV positive employee was dismissed because of his co-workers' fear that they would get infected with the virus as well. And in that case, the court paid particular attention to the fact that the applicant's illness was not in fact contagious. He hadn't even shown some symptoms, and therefore it found that the national authorities had failed to strike a fair balance between the competing interests, because there was not in fact a danger of transmission of the disease. Therefore, if someone is not in fact does not in fact pose a danger to his co-workers, I don't think that dismissal would be found as a proportionate measure. And after all, we saw that in the Pavlichka judgment that the court paid particular attention to the fact that the measure of compulsory vaccinations was only indirectly imposed through protective measures. And I do not think that the measure of the dismissal, which is not of moderate intensity, but it is in fact the strictest, the strictest means that can be through which the measure of compulsory vaccinations could be imposed. I don't think that it would pass the proportionality assessment of the court. But something less intense, like I don't know, the obligation to provide some negative tests, for example, more regularly, that might be the case. But a dismissal, from my point of view at least, it does not fall within the ambit of protective measures that would be excused by the court, especially when it's done by not the state, but not state actors, business, for example. Thank you for your attention.
Can I jump in here? Actually, I strongly disagree with you, Sissy.
I was sure.
I would be shocked, okay, if any of these kinds of regulatory interventions that mandate vaccinations in specific settings were overturned ultimately either by high domestic courts or by the European Court of Human Rights on human rights grounds. It really depends on the context, right? So if you're a truck driver and you're the only person in the truck and your employer tells you you must get vaccinated, and if you don't get vaccinated, we're going to fire you, that's one thing. But if you're interacting with other people, you're constantly endangering other people by your mere presence. And employers of all kinds will start soon requiring vaccinations. Now, this all, by the way, assumes, of course, that there's sufficient supply of vaccines. If there's no sufficient supply of vaccines, we're in a different kind of story, right? The unfairness is completely right. But if there is a sufficient supply of vaccines, if my university starts telling staff, if you don't get vaccinated, we're going to fire you, or, there's no way you're going to get an exemption that you cannot teach in person. You have to teach in person, right? Et cetera, et cetera, et cetera. No British court will overturn that simply because you have personal views against vaccines. The one caveat here is that the vaccines we have so far have emergency use authorizations, really. So they do not have final approvals and licenses from regulatory authorities. But once that is there, and once the health risks are, at least as science is concerned, completely clear, there's just no way that judges will intervene in this. It's just so, especially Strasbourg is so cowardly, generally speaking, that there's just no way they're gonna intervene on these things, right? And back to Pierre's points on business and human rights, that is the big thing here. That's the game that's being played now. If you look at digital platforms, they have realized that human rights is the only universal language that they have. There's no language that they have other than one of human rights that can, if you're Facebook, cover all of your 2 billion customers worldwide, right? So if you look in particular, for example, at how Facebook has now formally adopted its human rights policy, if you look at how the Facebook Oversight Board is completely using human rights analysis in its review of what Facebook is doing, say with regard to the Trump ban, whatever, what we're going to see, at least in that context, is the complete mainstreaming of human rights in the decision making of these corporations. And that, I think, is a good thing. On the other hand, it can also be seen as a justification for, justifying the horrible things that Mark Zuckerberg and Facebook have done to the world, in a sense, in human rights terms. So maybe it's not wholly good.
Maybe if I can just add several points. So first of all, I totally agree with Marko that it's important to point out that we are talking still about the emergency use of vaccines for the time being. And once they are approved, just like other vaccines that we have been using for ages, the situation changes, I think, even more in this direction that you have been talking about, Marko. Now, as regards private companies and kind of setting an ultimatum to employees to get vaccinated or get sacked, you could easily have a situation also which involves the application of EU law. Think of a cross-border situation. You have a doctor or a nurse coming from Croatia or Romania or wherever, wanting to work in a German hospital, okay? Yeah, so a very likely situation. And she can do that, she can get a job only provided she gets vaccinated. And as I mentioned, is that it will be justified, even if this case can appear before not only a domestic court, but also through a preliminary reference procedure before the Court of Justice of the European Union, that the courts will state that this is kind of justified and proportionate, considering the fact that these are high-risk jobs, jobs in hospitals, nursing homes, and so on. The question is, what about people who cannot get vaccinated, not because they don't want to, but because, I don't know, they have certain autoimmune sicknesses, diseases, or whatever? They will be discriminated, yes. If we are not talking about high-risk jobs, okay? So for high-risk jobs, I think these measures will pass before the Court of Justice of the European Union, if the case comes there. If you have just a regular job, then the situation might not be that easy to judge from the proportionality perspective. And I'm sure that there will be cases where private companies will do something like this. The situation has here to be differentiated from a situation where you have a one-off situation. To give you an example, if you want to go to a hairdresser's, want to go to a cultural event, to a concert, and you have either to be vaccinated or have a negative test, that's fine. But they cannot say that you have to be vaccinated and that's it. They have to offer you an alternative, just like maybe an airline company has to offer an alternative to vaccination if you want to get on board. And for example, France had a pilot project where they asked people who wanted to travel to their overseas territories and to have a kind of certificate, but they would also accept not only vaccination, but also a negative test. And that's acceptable because there is an alternative.
Yes, thank you for your remarks. And we already have the next question coming up in the chat by Marijke Meijers, and it's directed at you, Iris. And she asks, how do you assess the application of...
Can I react? Can I ask? Oh, okay.
I don't know if I have connection issues or...
Go ahead, I'll write something in the chat.
Oh, all right, I'm sorry. So Marijke asks, I have to look for it again. How do you assess the application of vaccination prioritization for certain groups of people, or vice versa, of restrictions for certain groups of people to get vaccinated, like children or pregnant women, as it is, for example, in the case of Germany right now, that there's no, there are no rules for that.
Okay, as regards the first part of the question, the prioritization. Well, I know that there has been discussion going on whether we should first allow the vaccination of the most vulnerable groups, or maybe of those people who socialize most, because, you know, that will have a wider impact on the society. Personally, I'm in favor of, you know, enabling vaccination of the most vulnerable first, no matter whether we are talking about protecting people who are in old age homes, who are a certain age category, or people who are in hospitals and so on. So I find the approach that has been taken socially acceptable, even though maybe, and I don't know whether this is the case, that was not the wisest approach if we look at, you know, the numbers in the end. So maybe the better approach would be, let's treat everybody who socializes most first, because that will kind of limit transmission. I don't know. As regards restrictions for certain groups of people, yeah, you know, this is the result of scientific uncertainties associated to the vaccination, and the fact that it's currently used only for emergency cases during the pandemic. So, and this is changing day by day. So I kind of, we don't have a choice. We just have to believe in science and see how it goes.
Mm-hmm.
Okay, thank you. I have another question to Marko. Let me start with a quote from an article of yours from April 2020, if I may, because with really remarkable precision, you have predicted that, I quote, "A mass vaccination program conducted a year or two from now seems to be the only viable exit strategy for COVID. And that program will inevitably run into virally misinformed anti-vaccination activism. Moreover, a failure to learn from COVID-19 misinformation will leave us all the more vulnerable to some future pandemic." Now, what are these lessons we can or should learn from this misinformation, which has, like COVID itself, accompanied us for now 1.5 years?
I mean, I don't know. It's a really difficult question. I suppose. I mean, in some ways, the response to the pandemic has been way more advanced than one could have expected, right? So if anybody told me that I would already be vaccinated, you know, a year ago, I would not have believed it. So the scientific progress in sort of testing all of these vaccines and deploying them, manufacturing them, has been amazing. On the other hand, the response to the so-called infodemic, right? So the ability to actually deal with all these types of misinformation spreading online, and not just about vaccines, but about all forms of COVID-related misinformation, has been very depressing. There is not a single state or digital platform that I would say, okay, look at what they've done, copy them. You know, they're the model we should all strive for. All of them have shown, you know, exhibited enormous failures, and partly that's you know, a consequence of the state of our societies in 2021, and sort of the very polarized environments in many of these countries, the culture wars that they have been embedded in them. I mean, look at, for example, how in the United States, the sort of vaccine denialism or generally skepticism towards various other public health measures like masking has for various reasons sort of shifted into a completely politicized divide. So I can't say we have done particularly well on that basis, but to do better, you know, I think companies need to get more regulation, and these are inevitably going to get more state regulation. But our societies need to be in a better state of mental and political health to actually handle these better.
Yes, thank you. So I think as we all see, we are already coming to the end of our webinar. And so unfortunately, we do not have the time to answer all of your questions, but we do want to have some kind of a closing question for the entire panel. And we were wondering if you could tell us your short opinions in a few sentences on the takeaways, that maybe are there some promising things we can see with regard to vaccinations and international law, or are the takeaways rather that international law looks rather grim to tackle the issues of human rights and vaccination? So I don't know, maybe Sissy, if you want to start, then you all have a couple moments to elaborate on that.
Thank you very much, Lisa. I would just at this point just say that I am also very much interested in seeing what will happen, because I guess that these discussions that we're having now, we will soon receive answers from perhaps human rights forum in the upcoming months or years. So I'm also looking forward myself to finding out about the specific questions that I, as a person, not necessarily as a scholar, have. So yeah, but I am mostly interested in finding out about all this issue regarding the dismissals on grounds of vaccination. I'm pretty sure that in the upcoming months I will be emailing Marko and telling them that I was right. So we'll see. Thank you.
So I don't have any preferred order, so whoever of you wants to go next, Iris and Marko?
Okay, let me. I don't think the situation of international law with regard to vaccines is particularly grim. International law plays a fairly marginal role in regulating this whole area. The biggest failure, if you will, of the global order, including the legal one, is not in the issues we have discussed today, but in the issues you have discussed in the last seminar, which is the inequitable availability of vaccines worldwide. So that's the biggest failure, the fact that the rich have them and the poor generally do not. But that is a problem of such magnitude and it's so cross-cutting. It goes against so many different fundamentals of the world order as it stands today, that it's not the law that can solve it, right? I mean, it's not a legal problem. It is a legal problem in a sense, but it's not the law that will provide solutions. And I think, the one thing human rights law does in particular does very well, it provides a structured framework for thinking about whether particular measures are justified in balancing interests that are often competing. And that, I think, human rights law does reasonably well. In the vast majority of situations, I think that the bottom line will be that various public health measures are justified, and the litigation will only be on the margins. But let's see how that plays out.
Okay, shall I say something, Lisa? Yeah, okay. So maybe 2 points. First, I think that I'm talking about the EU law here. So when it comes to COVID certificates, I think they are a kind of from the European Commission's perspective, they are seen as a kind of a victory because of the failure that the distribution of vaccines we had at the beginning across the EU and the problems associated with the distribution, for which the European Commission was blamed by a number of member states. The Commission really insisted on pushing forward the adoption of the regulation on COVID certificates. So they really they needed it politically, socially, whatever. So they see it as their little victory, I would say. And I see it also as a kind of a way for the EU to say, okay, EU free movement law is not really in danger anymore. not in such a great danger, because what was happening at the beginning was the biggest ever threat to the functioning of the EU internal market. From a wider, more general perspective, if we look at the pandemic as a kind of a crisis, an EU crisis, what does it mean for the EU and its future? I just compare it to any other crisis the European Union has been through over the past decades, and did all these crises mean the end of the EU? No, they didn't. If you look at the financial crisis, if you look at the refugee crisis, and if you look now at the pandemic, the EU maybe didn't come out stronger, as some argued, but it came out more integrated. And I think this is just a regular response that's been reoccurring over the past. Every time there is a crisis, the EU realizes that the answer to the crisis in the end and for the future is even more integration. And I think this is going to happen also when it comes to the pandemic. And, there has already been talk about the creation of the European Health Union. What would it mean? It would mean, to a certain degree, even more coordination of health policies, which are member states' competence. So I think that what will be happening is definitely more and more integration to prevent similar pandemics, similar crises of having such a shock at the very start. And this is what I see as the main outcome of the pandemic in terms of the global functioning of EU law. Thanks.
Well, that would indeed be a positive takeaway. Now I have to announce that we unfortunately have reached the time limit of today's webinar already, although I would have loved to continue the discussion. And I would really like to thank you, to thank our panelists for having taken the time to join us today, for their insightful presentations and for answering so many questions. I would also like to thank everyone at the Institute who helped us organize this event, in particular the student assistants and everyone involved in our research cluster on human rights and humanitarian protection. And last but not least, I would like to thank you, every member of the audience, for joining us today and for engaging in the discussion. I hope you have taken something out of this webinar. I surely have. Thank you.
Yes, and before we finally close this webinar, I would, of course, like to join Rouven in thanking all of you for being with us today. It really has been a pleasure to host this event and the overall webinar series on COVID-19 vaccinations and international law. And we're just very grateful for all the remarkable input by the 6 panelists in total. And if you would like to re-watch the webinars, you can do so on the Völkerrechtsblog. The recordings will be uploaded, I think, shortly after the event. And of course, we're hoping to welcome you back anytime soon, virtually or even better in person. And yeah, with that being said, thank you very much. Have a good day and goodbye.
Thank you. Bye.
Thank you.
Thank you.
Bye.